The Lahore Biennale team welcomes everyone and is very happy to have you guys here. In no particular order, Fatma, who is our head of PR and public engagement, Zoya and Mina, who's been dedicating to the project behind the scene with research and development, Rizwan, who's in charge of all the collateral and design that we send out, Umar, who's absolutely new in the team, but he brings a lot of zeal, a lot of attention, a lot of structure through his HR concerns, Noor, who's been working very hard towards the Biennale, and I don't think I'm missing anyone now.
Yes, good afternoon. I will be very brief. My name is Stefan Winkler. I'm the head of the Goethe Institute in Karachi. This is a German culture institute. We do not have a branch here in Lahore, but we are supposed to do activities in other parts of Pakistan. And here we do it, for example, with the Lahore Biennale Foundation, a wonderful partner. And I'm very happy that this event here, the public talk, the public lecture we are going to hear, is the starting point of a workshop that Paul Keller will conduct. He's a German, but he's based in Amsterdam in the Netherlands, and I'm very happy that we could convince him on a very short notice to find a time slot for us to starting point. The whole project is called Urbanities. My project coordinator, Sarah Duana-Meyer, is also here at this moment, and she's our arts consultant and the very important link between us and the Lahore and the LBF. And this workshop is the starting point of this project, Urbanities, Arts. I will finish and I will give the word to Samina Rafi, who is the head of the foundation, and she's going to inform you about the talk. And
Vice Chair of Kennisland, an Amsterdam-based think tank focused on innovation in the knowledge economy. Paul is also public project lead for Creative Commons Netherlands and a leading expert on open licensing systems in cultural heritage. From 2009 to 2013, Paul has been Creative Commons Collecting Society's liaison. In this role, he was instrumental in negotiating pioneering cooperations between Creative Commons and various collective rights management organizations.
Written there, like the ideas behind copyright, how copyright relates to art, and how copyright has inherent in its functioning a attempt to strike a balance between the protection of the interests of creators and the protection of the interest of the public to have access to information and culture. About 10 years ago, I worked for another organization then called Waag Society, which is a media lab, and we had a collaboration with a place in Delhi, which is called Sarai, which is a also calls itself a media lab, a kind of art space in Delhi. And we organized an intervention called World Information Organization in Bangalore in India, where we had a 2-week festival that had urban interventions on the question of intellectual property mainly, also questions of ownership of information more broadly and privacy, but a big part of that was intellectual property. So naturally this invitation here reminded me of that, and you can see on the background one of the interventions that we had done, which was this poster campaign with lots of questions throughout the city center of Bangalore. And you can see that 10 years ago, this was very much already a very politicized questions around questions of ownership, around questions of access, questions of criminality, piracy involved in there. And that really strikes with that, maybe that green, oh, thank you. With that green poster, one of the key questions that I think my organization is struggling with and that I am struggling with and lots of others are struggling with, if information is the most basic commodity of our times, and certainly that will differ according to where you are in the world, but certainly in countries like the Netherlands, there's basically almost everybody I know, and probably 70% of the population works in some way or other in shuffling information around, right? Like be that in terms of visual information or law, but it's very much not a tangible society anymore. We don't trade in goods anymore, we trade in information. And so the questions around how ownership and access to information is governed is a very important one, about not only about the specialized field of copyright or the specialized field of the arts, but more broadly about social justice, about like who has access, education, human development. All these questions are very tightly interlinked into the copyrights, into questions about copyright. And a lot of things have changed in the past 10 years. And I just, we talked on the phone when we prepared this, or on Skype actually, when we prepared this a little bit about how things have changed. And I looked a little bit through my photos, and this is the type of mobile phone I used back in those times. Like, I'm pretty certain, I'm not 100% sure, but it was probably my first mobile phone which had a camera on the back and which produced atrocious pictures, like this big and pixeled, and like it didn't even have a full color screen. And if you just imagine, like in terms of creativity, what, by the way, and it also, like I took this picture because I took it back from India. It had an Indian SIM card in it, and somehow it thought I was in Afghanistan when I was back in Amsterdam back home. So it didn't, I've never been to Afghanistan yet, but like my phone apparently thought it was in Afghanistan once. But if you think about like the change, like if you look around how people perceive, how people stood in here, like everybody's taking pictures. Like pictures are works, photos are copyright protected works. We're sharing, we're expressing ourselves so much more easily, readily. There is the production of photos goes through the roof. Like there's, and these are not very recent, but there's more than 1 billion pictures shared every day on Facebook alone, right? Like, and if you look around from the copyright perspective, these pictures are pretty much the same as the artworks that surround you. Like if you think what the artistic production in terms of output was in like not even 50 years ago, when making like a creative work that attracted copyright protection was the exception, like it has become the rule. It's been like everyday activities these days. So, and that is something which has changed enormously over the last 10 years. So that by way of introduction, why this topic interests me so much and why I think it's why this is something that we spend a lot of time working on in the Netherlands. My work at the moment consists very much, not so much on operating in artistic contexts. This is a bit of a excursion to me, these 3 days that I'm going to spend here. Like my main work is spent working with cultural heritage institutions, so archives, libraries, museums, who face a lot of challenges around copyright as well, which are mainly related to access. And we work with them in helping them deal and understand with the issues, but I'm also, when we are working with them, actually going towards mainly the European Union. The government, the European Union in Europe is in charge of copyright, to try to advocate for better rules that strike a better balance. But let's go back to copyright and why we have copyright in the first place. Like, so what's the purpose of this thing called copyright? And I think probably the most well-known, if there's something like a well-known explanation for copyright, is the American one. This one sentence is called the Copyright Clause in the U.S. Constitution, and it gives, like, it's the legal basis for copyright in the United States of America. And what's specific about this is that you, from an artistic area, you would probably to protect the interests or the creations of the authors. That's not the case here. That is a very utilitarian approach almost to copyright. It says to promote the progress of science and useful arts, so not like the non-useful stuff that you are probably all know. So the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So this is a time, obviously, United States Constitution, when the main body of protected works was writings. This has been extended with like the explosion of artistic forms over the 20th century. But here we have something that gives Congress the right to pass laws in order to promote the progress of science and useful arts. So it's very utilitarian. And that is, to this day, this has meant that there's a slightly different tradition of thinking about copyright in the United States than in certainly in Europe, but I think in most other parts of the world. So the US is a little bit the exception here. The result of this is that the US has a very almost economic approach to copyright. They are economic rights, they are tradable, and they are very functional as something. And as we know, like especially in the digital space, the US kind of like dominates a lot of discussions, a lot of discourses, and it's good to keep this in mind that they are, at least by historic tradition, are thinking slightly different about copyright than a lot of other societies. Does anybody know which beautiful city this is? Yeah. So, but you didn't recognize it from the buildings, I'm pretty sure. You deducted from the fact that we're still talking about copyright. So Bern in Switzerland, it's a small German-speaking city in Switzerland. It is maybe the most important city, or historically the most important city for copyright in the world. Bern is the place where something called the Berne Convention was adopted. The Berne Convention was adopted in 1996, so that's 120 years ago this year. And which the Berne Convention really lays the foundations of the international copyright framework as we know it. The Berne Convention is, and it's been followed up by a number of, but Bern is like copyright lawyers or people talking about copyright will talk to each other and sometimes say things like, that's not possible because of Bern. And then it's end of discussion, or sometimes like then somebody, oh, maybe I know a way around it. But so Bern is kind of like the reference point of a lot of discussions. This convention has been signed by pretty much every country in the world. I think it was one of the first things Pakistan acceded to once it became an independent state in 1948. So it's one of the most universal treaties that are out there in terms of international treaties or conventions that are joined by member states. And it is the outcome of people like this gentleman, Victor Hugo, the famous Frenchman, worrying about how to deal with the protection of their creativity, their artistic output in a world which was, for those standards, globalizing at the point. The thing was, copyright is a legal construct, and so you can have and you had a copyright law in France, and it said, like the French law said, somebody who is an author shall enjoy artistic exclusive rights over these works. So like it's the person who decides about making it public should reap the benefits. The problem being around that time with the printing press, but especially also with the ability to trade compositions, so scores, and you could somebody would compose music, but those scores could be brought to another country. These laws were territorial, right? Like if you brought an artistic work to London in the United Kingdom, which isn't that far away, French copyright law didn't apply, and so what the Treaty of the Convention of Berne tries to fix is this problem that your government can only grant you this copyright protection where its laws apply. It defines a number of criteria, minimum criteria of copyright protection, that states that sign this convention need to be nationals of other signature states. So if you wanted your French citizens to protect it in the United Kingdom, and the United Kingdom wanted the same, like it becomes kind of like interlinked, and because you want yours protected, you agree to have the other ones protected in the other territories as well. And that proved to be a very successful model, which spread to like almost all countries of the world. And as such, this is really like also still the basis for copyright, because it's incredibly hard also to change something or to update something which has been signed on by 180 plus states. Like you all need to agree to change these things. So there's minimum requirements laid down in Berne that are still valid today, and some of them cause trouble today, some of them may not cause trouble. There's been like a number of subsequent treaties, and I think you will go into them. Like there's something about the Rome Convention, and then the Wipo copyright treaties and TRIPS. I'll leave that to the side, but this general idea is the law is by definition territorial, but we make these agreements so that the protection is mutual between the countries. The general idea is they were really concerned about this thing in an environment where the idea of copyright was established at the national level, and where works of like creative works started to circulate much wider. Like this idea was we need to have an international system that protects copyright because the exchange of art and culture isn't something that stops at borders. Sometimes it stops for linguistic reasons, but like in general, that's probably not the case. At the same time, and the answer to this was this idea of exclusive rights to the author, the creator of the work. At the same time, even the people who were the staunchest proponents of this system of exclusive rights were very much aware of the fact that that causes problems. Like you can't, like knowledge, information, access to culture cannot be completely commodified and locked off. And this is a translation of a quote in French that is also from Victor Hugo, who was really the driving force of copyright. And he says that a book like belongs to the author as a book, but as a thought, it belongs to humankind in principle. And he goes on to say that if ever you need to make a decision between like whose rights, humankind's right of access to this thought, or the author's right of exclusive control over the book needs to take preference, it would clearly be always humankind's access to the book. So copyright wasn't, you can see these people, copyright wasn't necessarily conceived as something which should be used in order to block off access to culture, but very often like something like an instrumental thing in order to enable the circulation of culture. And this tension is still very much alive. It was there from the beginning, and it is like what I'm going to spend also like a little bit this, because it was fairly recent. This is on a national state level. Does anybody know which building this is, or which building in process of becoming a building this is? So it's the Atomium in Belgium, which was built in 1956 for the World Exposition, which became like this shiny steel thing, which represented an atomium, which kind of like illustrated the sense of the time of like nuclear energy being the answer to everything. It's one of the most famous buildings in Brussels, or in all of Belgium, and certainly like one of the most photogenic buildings. But you couldn't take a picture of that and then publish that until 3 weeks ago. And that is because Belgian copyright law did not have an exception in it which deals with what's been tagged freedom of panorama. Pakistani copyright law, I think, has it, and a lot of other European ones have it, that you are free to make a reproduction of an artwork if it's visible from public spaces or something. In other words, and most buildings are artworks. Certainly sculptures, and certainly something like the Atomium is an artwork. As such, they are protected by copyright, and as such, if the author, like the architect, or whoever has been responsible for that building hasn't been dead for 70 years, there's copyright. It's the exclusive right of the creator of that thing, and you need permission. In this day and age where everybody has a mobile phone and makes selfies, it's becoming like a little bit of a unworkable situation where you go, and every time you take a picture of the Atomium, or another example is France has the same thing, has the same situation where, at least for commercial purposes, it's not allowed. The Eiffel Tower itself, like the architect, is it's out of copyright, but there's night illustrations, like there's illumination on the Eiffel Tower at night, which is an independent artwork. So it's technically illegal to post selfies with the Eiffel Tower at night. So, and you see, like a lot of countries, Pakistan has this in order to enable certain things where there is a public interest, and there is a public interest, for example, to take pictures of your environment, or where it's simply impractical in this case, you could argue. It is completely impractical in this case, but it has.
Absolutely, it's ridiculous because their paradigm is shouldn't these laws change with time? I mean, these laws might sound redundant in a day and age when everyone has a camera to capture images.
I mean, you're touching on a very, very important point. Like, obviously, like I'm not necessarily like explaining here what I think the world should look like, but I'm rather trying to describe the world as it is. But this is one of the main struggles in this field, and there's again two different approaches between the European Union and between the United States and pretty much the rest of the world. Basically, a system that was of interest to a relatively limited group of professionals, be they publishers or professional creators, professional intermediaries who could access, who had generally access to lawyers. So it was kind of like professional, almost sectoral, legislation that was of interest to structuring business relationships for a good deal, and often very, very
Sort of specialized, right?
yeah, it was a specialized field of law that didn't impact anybody. The moment where the internet comes along and everybody can publish, and even more like where the mobile phones come along and everybody can publish really quickly, it becomes something which is suddenly touching on everyone, and people are often not even aware that they are touching it. So there's a lot of movement around copyright. There was around 1996, the Wipo Copyright Treaty tried to establish a number of principles around copyright in the kind of like internet age, in the digital environment. It concerned it primarily with kind of like infrastructural questions of publishing and making sure that stuff that happened on the internet was actually covered by copyright. And I think that is in 1996, the Wipo Internet Treaty. In 2001, for example, the European Union, but also the United States, updated their copyright law to reflect these ideas, reading them. And so, of course, it's allowed. And there's others who are saying, like, computers make reproductions all the time. A computer isn't just reading, it makes internal copies all the time. Of course, this requires permission. And as such, like, a university researcher cannot do this without asking permission first. So there's these tensions where, like, stuff is too old and it starts breaking up, right? And a couple of more thoughts before I wrap up on the situations of artists. Like art is very interesting, right? Like art in its like copyright becomes maybe much more relevant and much more structuring in its application, where it comes really to mass culture, popular culture, stuff that is disseminated widely, which is on radio and television and things of that. Because like we all know things like there's also art where you have appropriation art, where there were people who made exact reproductions of Warhol's works as art, which was even recognized by Warhol as in its exact reproduction as something which was an independent artwork, where, like, from a copyright perspective, this is clear copyright infringement, and this wasn't, she didn't ask for permission for this stuff, she just did it. So, like, in the higher the stakes get, like, but also you can sometimes get away with a little bit more, right? Like, this is, if somebody would have printed a book of this and sold books and saying, like, here's an art, that would have probably something Warhol would have fought with copyright law in hand. But like in art, sometimes like these transgressions, sometimes not respecting copyright, overly quoting, incorporating stuff can also be part of artistic practice. And so this is something that I think the law also has a lot of difficulties of dealing with. And which can, like, which creates an endless array of interesting conflicts that keep lawyers busy, that keep, like, that are also very interesting to analyze, but that also always express this tension between, like, this idea of individual autonomous creation and the fact that we are all relying on what's around us in order to create and go on. So that is maybe one topic which I thought is
Why are we here? The Kutsia came to me and told me to talk here in Germany. I said, what can I do? Is to protect the artists in Pakistan, the architects, people who are linked with art, how to protect them, where to register, and how to make them rich. According to what the painting was, the poor artists have to be protected. Purpose was that before we speak, I want to give you an overview. We are in Pakistan. Pakistan is a state. Do you think our country was supporting us to protect the artists, or it was international pressure? Because artists has been there for almost with the Western world. We talk about copyrights. We talk about the case that the Mughal made Taj Mahal. They cut the hands that do not copy this for others. Okay, and every copyright, every architecture, every art has to be protected, and it has been done for almost centuries. Had Moses, when Michelangelo carved Moses out of the rock, and he for 3 days a blind man was holding the statue like this. Please speak. I can hear the heartbeat. The statue couldn't speak. Broke the arm. Priceless issue. Because who created you? It's a concept of the originator or the author, or what is the word, whatever word I'll clarify in the law is the meaning of an artist, the creator, the musical work, the literary work, the dramatic works, and how Pakistani artists are protected. And I must say that I was always defending the corporations of taking poor artists' rights away when they're employed. Then I realized after the Hum TV case, no, I will work for the artists. And since last 10 years, I'm promoting the subtle art of Rizal Majid, the Lahore Jazz Festival, the entire song he creates every day. Of Ataullah Izzakebi came to an office, he said, I sang some songs 20 years ago, EMI signed some documents to me, now Nescafe basement is now playing my song. Somebody from India is buying that from that Nescafe basement, I can't be the originator. So we defended that case with my team. We said, no, I was the moral right. The concept of artist moral rights. So we talk about children's rights also. How can they be protected? Where to go? When to go? How to go? Why to go? So the next issue is, what is intellectual property? I don't go straight to copyright. Because I'm a lawyer, I have to build my case. The intellectual property are of 5 kinds. We have a property. My watch is my property. My car is my property. Which is the physical property I have. But what is the intellectual property? It is something which I, with my reputation, with my hard work, with my 20 years, is something I make out. An artist make out. Poet, lyrics. Anybody who comes out with a concept is that here is relating to one's ability to think and understand things, especially complicated ideas. You guys originate something. This painting needs to be protected. That statue needs to be protected. Somebody has made that. It's his own creation of carving out from wood those 2 statues which are missing, I think, or Hati, I don't know. Okay, anyways, so property defined, and what is intellectual property in Black's dictionary is intangible rights protecting commercially available products of human intellect. Paul spoke about some ideas. I linked them with the Pakistani law, and in my second presentation, that how you guys are protected. From tomorrow onwards, your thinking should be, I want to sell myself like the West world. Next, trade first is the trademark. When you make some name, you make your name, so you always have a mark. That's called mark. You can't use that because it's protected all over the world. The trademark everywhere is different of M, whatever word you use. Then trade name and a company name are different. When you use a bottle, Nestle, when you turn around, or even Perrier water, you turn around, it's by Nestle, but for product name is, company name is something else, trade name is something else, trademark is something else. These 3 things are linked with the concept of trademark laws. And there, because of your reputation, people buy brand concept is by the trademark issue. And this is the most complicated area, which is called copyright. We are also in the copyright. I'll explain there are 6 kinds of copyrights in the world. Under the Berne Convention, under all the conventions, artist, literally, author, dramatic performances, everything. When we go into the definitions, and every word is covered to protect this art. So that is why when I go into detail of copyrights, patent and then design. Whatever, this is my design, you can't copy it. After 50 years you can, but you can't do that because I created this, I'm a creator. So I created this and this is my thing. Do not copy it or make money. The concept is all commercially issued. Don't make money on my product. Lucia said, I had an artist who designed something here for the exhibition. Somebody stole his idea in dash dash town. So we won't name anybody, I don't want to be sued tomorrow. And how can he be protected? It was he came out. Children in your school, they make out something, we explain, the children do fit into the law. So these are issues we need to talk. Rabia is going to ask lots of questions. We will also say, how is she protected with her art? Next please. Copyright granted by statute to the author or art originator of certain literally, so I will spend 4 minutes, what is literally artistic production where he invested for limited period with the sole and exclusive privilege of multiple copies of the same and publishing and selling them. That's my idea. Rabia makes out the painting, she wants to sell it and to make money. So is that I want to multiply my copies, like Van Gogh's painting, I want to multiply my copies, I want to sell them in the market to make money. That's all, everything is a trade. And all artists, they do meant, though this saying something, they say that all big artists, they died poor, after that their family inherited the entire money. Like, so the concept is why were not they protected, which was the concept starting for, as Paul said, Berne Convention in 1893. In Switzerland, they sat down and discussed this issue. Berne. They explained how Berne is applicable to us. Then the trademark in marking by a company. So everybody should know this is my product. When you do handling so many cases in Pakistan, and you come out with fighting out of courts, even the color of orange Nikes for with the U-phone. Even in the case of we were dealing with some trademarks are so popular that people use them. Mobile oil is a company, but you said it's lubricant oil. In Pakistan, they say mobile oil. If I want to change the mobile oil. Mobile oil is just a company's name. Or Jeep. Can I use your Jeep? Oh, I'm sorry, it's a 4-wheel car. It's not a Jeep. Its wording is called 4-wheel car. Can you courier this? No. He said, DHL, no. This is courier. So these are some products have become so popular that people use that name of a product, but product is something totally different. So the concept which came out in Pakistan last year by Honorable Supreme Court of Pakistan, they were assisting the court, they came out with the idea of copyright and trademark. The distinguish between copyright and trademark came in Pakistani Supreme Court in the Farouk ghee oil mills, the issue of a ghee name between two their Supreme Court held copyright materials could not be allowed to be an alternate or a substitute to a trademark unless of course such copyright in artistic work is also registered under the Trademark Act. So sometimes some copyrights are also into a trademark.